Coming up on Primetime Politics Weekend, defending his decision.
There was a use of children as human shields deliberately.
The Prime Minister testifies at the Rouleau inquiry, explaining why he invoked the Emergencies Act.
There was not confidence that we were on a track to getting the national emergency under control.
Also explaining why he believed the protest amounted to a national emergency. We'll share details of Justin Trudeau's testimony and assemble our strategists to assess the impact of the Prime Minister's words. This is Primetime Politics Weekend. Hello, everyone. I'm Michael Serapio. It is rare for a sitting Prime Minister to appear before a public commission, but that is what happened this week. Justin Trudeau testifying before the Rouleau inquiry, explaining his reasons for invoking the Emergencies Act as he answered question after question under cross-examination.
With the mayor and who?
Some of the convoy organizers.
Which ones?
Well, Tamara Leach, who's present here in this room, signed a letter. It was made publicly available on the news on Sunday, February 13th, and you were advised of that agreement at the IRG meeting.
And we were also advised that that agreement wasn't holding and that many of the convoy had decried it as fake news and not actually an agreement that they would abide by.
The Prime Minister's testimony wraps up this portion of the Rouleau inquiry. And to discuss what was shared, we are joined once again by our journalist panel. Joanna Smith is the Ottawa Bureau Chief for the Canadian Press. Chris Nardi is parliamentary reporter for the National Post. Good to see both of you.
You too, Michael.
Hi, Michael. Good to see you.
And you. Listen, before we get into the details of today, I actually want to begin here with your impressions, because as I said, it's not often that we see a sitting Prime Minister testify before an inquiry. But Justin Trudeau said he wants Canadians to know that, quote, the inputs the government had in making this decision. Joanna, what do you make of the Prime Minister's testimony? Was he open enough?
So it's interesting because I think yesterday I said I would be interested to see if he was introspective at all, as he sometimes is. And he was in a way, not in a reflective, self-critical way, but he sort of, in his really key part of his testimony, let us in a little bit into what he was thinking exactly in the moment. It was 3:41 p.m. on February 14th when he received what he called the decision note from the clerk of the Privy Council, the head, top civil servant in Canada, recommending the Emergencies Act be invoked. And he said he thought to himself, okay, what if I don't sign it? What if I wait a few days? And he sort of walked us through an imaginary scenario in which he waits a few days or doesn't do it, and maybe a police officer ends up in hospital, maybe things get so much worse. So I think he, and then he said that he could potentially have ended up testifying before a public inquiry for very different reasons. So I think he did answer that question directly in the sense that if he, as Prime Minister, ultimately bears responsibility for this decision, then he confirmed that it was in fact his decision. But at the same time, he made it clear that he was getting all these inputs, that word we keep hearing over and over again, that he was comfortable. He was in fact absolutely serene in making the decision because of those inputs, in particular the sign-off from the head of Canada's public service. And so, yes, it was his decision, but he talked very much about being a consensus around the table.
Yeah, consensus around the table. But again, here he is answering these questions, and as you say, being reflective at times. Chris, what did you make of the Prime Minister's testimony? Again, a rare event in this country. Was he open enough? Did Trudeau answer the questions directly enough?
Well, he answered the questions, but ultimately, Michael, the issue is that we still have that kind of key missing piece of information that we've talked about all week, and it is the legal advice that was, he said, given verbally by David Lametti, the Justice Minister, to Cabinet on the day before the Emergencies Act was invoked, and that basically explains their definition of the Emergencies Act and how, or the threshold basically required to invoke it. He did, though, dive a little bit more into the legal argument than I think any previous witness has this week. He basically explained that the part of the CSIS Act definition of a threat to national security that they were really intently focused on was the one that had to do with ideological or politically motivated violence. And that was the main core of the assessment that they were looking at and trying to determine if the Freedom Convoy did in fact pose a threat to Canada, both economically, both because of violence and because of the threat of weapons. He talked about, children being used as barriers at protests. He talked about a car that was run into a police car and into the police, generally speaking, in Coutts, Alberta. Like, that was all part of this larger, broader definition of a threat to national security that Cabinet considered. So it's a little bit of insight, but obviously he didn't waive that solicitor-client privilege that we've been hearing about all week. So I think that the Commission will still be hitting their head against the wall for that. But ultimately, yeah, I think Joanna made a good point. And I too was wondering, after she mentioned the introspectiveness that he can have sometimes, if that would appear today, and to certain degrees it does. He did say that he looked at the piece of paper that would invoke the EA and basically wondered, what happens if I don't do this? But, as Joanna mentioned, he's completely serene with that decision, obviously has no regrets, and we'll see if the Commissioner, eventually determines that he should.
And again, to your point, something that's been raised ever since David Lametti made his appearance at the Commission, the exact legal advice given by the Department of Justice has not yet been shared. Although I do want to play that portion of the testimony that you were talking about, Chris, that portion where essentially the Prime Minister points to the CSIS definition for a national emergency. Let's take a listen to his testimony.
That was what we were looking at. Is that threshold met? Are there activities supporting the threats or acts of serious violence, a threat of serious violence for political or ideological goals? If that threshold was met in our reasoned opinion, then that part of invoking a public order emergency was met. The other part of it is, does it constitute a national emergency? And there's elements on that I won't get into unless you ask me about. But I was very much focused on, was this bar hit? Yes or no, for the purposes of invoking the Emergencies Act.
Okay, Joanna, what's interesting about that is there has been, as both of you know, been a lot of discussion as to whether or not the government was bound by the CSIS definition of a national threat. But here you have Justin Trudeau referencing a definition within the CSIS Act itself. So how far, Joanna, does that go in justifying the invocation?
I think we're getting a little bit more insight into their thinking on this. I mean, when previously officials came and talked about the CSIS Act definition being too narrow, they were talking about it, like Jody Thomas, the National Security Advisor in particular, if I recall correctly, was talking about its need to be modernized, that it was too narrow because it was maybe out of date. And Trudeau framed it a little bit differently today. He talked about it being deliberately narrow and says that's because it was meant to restrain, to frame the activities of CSIS itself, not restrict the government, an elective government, presumably in a situation like this. And he says, he added the government is in fact allowed to accept input from other sources besides CSIS and its definition, including the RCMP, other federal departments and agencies, and that ultimately the decision rests with Cabinet. But again, as Chris said, as you said, we keep coming back to that key missing bit of information, the legal analysis that the Department of Justice provided. Everything seems to flow from that. His comfort with a decision that was recommended by the clerk of the Privy Council. She recommended that based also on this decision. So again, we're missing that really key bit of information that allows us to see really clearly exactly what they were considering when they made this choice.
We started by talking about Justin Trudeau's, performance on the stand today, but I want to put the whole government in this past week, their testimony into context, because the Prime Minister was the grand finale, if you will, the last person to testify. Overall, after weeks of testimony, if the Commission is meant to determine whether the invocation was justified, how well did the government, through its ministers this whole week, present its case? Chris?
Well, I think it presented a very strong political argument. I think it presented a very strong emotional argument. There's a lot of people, particularly Ottawa residents or people who were affected by the various blockades across the country, who will, relive the testimonies of the last few weeks and relive then the events of the Freedom Convoy protests and say, yeah, absolutely, that was a situation, and we needed to get rid of that regardless of what it took, right? Which government acted, we don't care. So I think on that respect, it's very successful. But ultimately, the Emergencies Act is a law. It requires a legal threshold to invoke it. And I'm not entirely convinced that that legal threshold will be met because, as we've talked about extensively this week, the government's invocation depends on a legal, let's say, definition that is not necessarily the one that seems written, pen to paper in the law, in the Emergencies Act, and in the definition of the CSIS Act. So the commissioner, I really do not envy Paul Rouleau, but his job will be to look at this and say, well, was the government right to interpret this more broadly without actually having the advice that the government relied on to do so? Or should we take the law as it's written word for word and say, well, sorry, if CSIS said there was no actual threat to national security, then you didn't meet it. So the legal argument is the one that's really tough to make, and I'm not sure that it was made.
Yeah, Joanna, what do you think? Because here you have, again, the Prime Minister, the Deputy Prime Minister, the Defense Minister, the Public Safety Minister, the Transport Minister, all appearing before the Commission. How well did the government present its case?
I think it presented its case well in the sense that I believe they all felt they were justified in invoking the Emergencies Act. But whether they were legally justified in doing so is still under that black box, as one of the commission lawyers said, because of that missing legal analysis. And the other thing that comes to mind is something that's been on my mind since the beginning of inquiry, and frankly, even during the Freedom Convoy itself, even before the Emergencies Act was invoked, and it was sort of the idea of it happening was in the air and in conversations, and my reporters were all in the thick of it covering this momentous event, was if the commission ends up determining that it was justified, is it only because things were so badly mismanaged and what could have been done better to prevent things from getting so out of control that anyone even started talking about it? I think that's not the decision of the commissioner necessarily, but part of his mandate is not just to determine whether they were justified in triggering this legislation, but to examine the circumstances around it. And I think what we have learned throughout this inquiry through testimony and documents has just confirmed 1,000-fold what we all sort of saw on the outside from the outset, was that this was just so overwhelmingly mismanaged and out of control to the point where maybe it ended up being justified just because up to that point people had not been doing their jobs properly.
Well, we await the final report from Commissioner Rouleau. Until then, Joanna, Chris, really appreciate the time once again. Thank you for this.
Thank you, Michael.
Thanks for having us. Have a great weekend.
You too. As we said earlier, the Prime Minister has stated he waived cabinet confidence, partially at least, for this commission because he wants Canadians to know the factors his government considered before invoking the Emergencies Act. And while he and his government have been criticized for suspending civil liberties, Trudeau pushes back on that, arguing the very work of this commission is proof that democracy is strong in Canada. Take a listen.
And it is a certain amount of comfort that, first of all, the system is working as it should, that people who are defending civil liberties are able to say, you really should be careful about doing this, maybe you shouldn't have done it, that we have a system pushing back on this, because it's a big thing, not a small thing to do this. But that also we were able to solve the situation with it, that there was no loss of life. There was no serious violence, that we were able to get neighborhoods back under control, border services opened, and there haven't been a recurrence of these kinds of illegal occupations since then. I'm not going to pretend that it's the only thing that could have done it, but it did do it.
With more on the Prime Minister's appearance, we're now joined by Susan Smith. She is a Liberal commentator, principal with the Blue Sky Strategy Group. Lisa Raitt is a former deputy leader of the Conservative Party. And Kim Wright is an NDP commentator and the principal of Wright Strategies. Hello to the three of you.
Hello. Thanks for having us, Michael. Hi.
Hey, Michael.
So, to have a sitting prime minister testify at a public inquiry, it can be obviously very risky. Susan, do you think the prime minister helped or hurt his cause by appearing?
I think he helped it. I mean, when have we last seen a Canadian prime minister sit for 7 hours and be grilled by lawyers and come out standing? He did. I think the prime minister demonstrated very clearly what was at play. I remind your viewers, for anybody who wasn't living in Ottawa, watching bonfires and jerry cans and bouncy castles and trucks without wheels and horn honking, what a horrible situation it was in the nation's capital, the border blockades that were costing us billions a day. So the prime minister, and I think this inquiry has demonstrated that the policing wasn't working. It was a failure of policing, certainly at the local level right from the get-go. There was a massive amount of confusion and no playbook, no way that these demonstrators, protesters, occupiers were being moved, swayed, or dissuaded from doing what they were doing, showing any signs of leaving. So the prime minister invoked the Emergencies Act, and he came and did just what our democracy provides for in this case. If you invoke something that's at this level, the legislation says you must come and there must be a hearing and there must be a report. And I think by waiving cabinet confidence, by having cabinet members attend, and by the prime minister himself standing there, going there and saying, I had to make a leadership decision based on all of the factors, all the evidence, all of the advice, and this is what we did, and guess what? It worked, and nobody got hurt. It was the right thing to do.
Lisa, what do you make of the Prime Minister's testimony? His government, as we said, has been criticized for suspending civil liberties with the invocation. Did he present a credible argument? Did he help his case?
So that's two different questions. Absolutely. I think he helped his case, but his case wasn't about determining if the Emergencies Act was invoked in a proper way. His case was about making the case to the Canadian public that this was the right thing to do. And I think he did very well on that. But the bigger picture for me, and the one that I think is of most concern, is whether or not, from a legal perspective, that this Emergencies Act was actually invoked for the proper reasons, hitting the right threshold, and doing it in the way that was meant to be from the legislation as it was set out in 1985. And we're going to have to see how the commissioner goes through it all. There was a ton of evidence that came prior to the Prime Minister's evidence today. His evidence is not indicative of everything. But what he has done a very good job of is shown that in making the decision, he was reasonable. In his mind, he was reasonable. And that is the test, whether or not it's a reasonable, whether or not it was reasonable for him to draw the conclusion. But Michael, the test is very high. It's threats to national security, of serious violence, that go to the sovereignty of the nation that no other law in Canada can deal with. Now, you can't really put all that in one word and then say, but bouncy castles. Those two things don't go together. So there's a high threshold. There's a reasonableness test. I think the Prime Minister will be found to have met it all at the end of the day. But I wouldn't expect that any other government should take this as precedent setting. This is dangerous stuff.
Mm-hmm. Now, Kim, the Prime Minister addressed the flip side as we talk about this, because he addressed the potential consequence had he not invoked the act. Before you and I speak, let's take one more listen to what we heard from Justin Trudeau today.
The professional public service had made a determination that the thresholds were met, that the use of it was appropriate and, responsible, and the measures were the right ones that we were going to put in it. And I said, no, you know what? Let's wait and see another few days, another week, to see if we really need to do it. First of all, what if the worst had happened in those following days? What if someone had gotten hurt? What if a police officer had been put in a hospital? What if when I had an opportunity to do something, I had waited and we had the unthinkable happen over the coming days, even though there was all this warning that it was possibly coming? I would have warned that in a way that we would certainly be talking about in a forum such as this.
Okay, Kim, what do you make of that tactic from the Prime Minister in trying to say the act was needed by exploring what would have been had it not been invoked?
Yeah, it's a bit of a false narrative, but what is staggering to me as I've been watching not only the hearings and testimonies, but during the convoy itself, this was a slow-moving convoy across the country. It wasn't like it just snuck up on people and automatically showed up. You know, there's a running adage that you could your dog could run away in the prairies. You could see it for 3 or 4 days. That's what we saw during the convoy. And what we saw was a woefully inadequate response from law enforcement, politicians, various orders of government, and how they wanted to interact or not interact with one another. And I get that there was also some, provincial elections that were flying, certainly the climate with the federal conservative leader at the time, and people not sure how to deal with this convoy that was really taking hold. But this wasn't something that was new. This was not something that they didn't foresee. They just didn't want to react, and until it was frankly too late and too entrenched, which then created additional problems with our largest trading partner in the U.S. when we started seeing border closures. This became inevitably a very bad situation that was going to end up requiring extraordinary measures.
So to explore the alternative, not worthwhile.
Not really. It's a justification later on. Maybe it was a bit of how they thought about it at the time, but from my perspective, this could have been very much avoided in the first place had they taken the convoy as seriously as they were gaining momentum and gaining speed across the country.
Mm-hmm. Lisa, I want to pick up on what we heard from the Prime Minister again in that last clip, because you've sat in government, of course, and I'm wondering about whether or not the consideration that he's putting out there, the flip side argument, if you will, does anything to sway a legal argument, and you're making the distinction between political and legal, and the very fact that Trudeau says, Lisa, that the threshold was met. Does any of that sway your opinion?
Well, I don't really have an opinion on whether or not they met the threshold. I believe that the Prime Minister feels that the threshold was met and it was reasonable for him to do so. And I think that's what this commission will find. Whether or not you can paint scenarios of what would happen if I didn't invoke the Emergencies Act, I don't know how relevant that is to assessing whether or not there is a serious threat to somebody's safety and security in the moment. But that being said, these are all things that went to his thoughts, his mind when he made the decision. They're all appropriate to be considered, and it's up to the commissioner as to whether or not they were reasonable in nature. Mm-hmm.
Now, that of course, we're now going to wait for a final report from the commissioner. That's still months away, but ahead of that, Kim, you referenced it a little bit, but I am wondering how you think Justin Trudeau will be judged by the Canadian public for invoking the act. We'll go one by one. Susan, I'll begin with you.
I think when he invoked the Emergencies Act, the public opinion was in favor of it. More than 70% of the Canadian public was supportive of him invoking the act. I think this testimony is going to reinforce, and this commission is going to reinforce why it was a good idea. We saw how the commission lawyers have to be tossed out of the room for sort of insubordinate behavior towards the judge. There have been wacky questions, conspiracy theories floated on that side. It's clear that Canada needed the Emergencies Act to be invoked. I remind people as well that it was invoked, things moved, things happened, and the convoy stopped, and then it was repealed very, very quickly. So it worked. I think the Prime Minister's decision will stand, and I think Canadian public opinion in terms of whether or not that was the right thing to do will continue to stand on the yes side.
Lisa?
No, I think this is going to be looked upon in the future, and legal analysis will go through it and whether or not it was an appropriate infringement on people's civil liberties at the time, after you take out all of the emotion around the convoy and what was happening. And there'll be a hard look at the Emergencies Act. I think that already officials are saying they have to take a look at Emergencies Act, because it's a bit stunning to me that you can invoke the Emergencies Act with such, I would say, subjective points of view as to whether or not there's a serious threat. As Susan points out, there was no violence prior to this. We're talking about only a threat of violence. And as a result, Lisa, it was... Mm-hmm.
Lisa, there was harassment of the people that were going on in the streets. I think that the level of intensity, and it was a tinderbox in Ottawa, and sure, people weren't beating each other with sticks, but they were defecating on lawns, they were harassing people who were wearing masks. There was all kinds of, like, the level a potential for violence was unbelievable. I'm an Ottawa resident. I've been here virtually my entire life. I have never felt like this. So I think the level for violence was there. The Prime Minister himself said these people didn't want to be heard. They wanted to be obeyed. They wanted to overthrow the government. What went on in Coutts, Alberta, and what was discovered with the guns and the Diagolon conspiracy folks and where they were going to go, and then the blockade at Windsor, I think the level of activity that was going on across the country very much justified invocating it. And when you talk about
quickly running out of time,
you have to look at the civil liberties broadly.
Okay, Lisa, quick reaction to that.
All I'm going to say is if you change the flavor of the protest and put a different government in place, you may come to a different conclusion. And that's the fear that I have going forward. I think it was a very light test that was applied in this case to suspend people's civil liberties.
Kim, you got 30 seconds. How do you think Justin Trudeau will be judged?
Look, I think all of this conversation about the Emergencies Act invocation is analogous to the use of the notwithstanding clause. If you like the people who are using it, great, have at it, but it gets used. Yeah. Once it starts getting used, it's going to continue and continue and continue to be used and not for, frankly, the good of democracy.
I agree, Kim. I agree.
Well, with that, thank you very much to the three of you. Really appreciate the insight. Susan Smith, Lisa Raitt, Kim Wright, appreciate the conversation. Thank you.
Thank you.
Thanks, Michael.
You bet.
As this phase of the Rouleau inquiry comes to an end, one detail remains unknown. Just what legal advice was given to the Prime Minister regarding the Emergencies Act? The Justice Minister did testify this past week, but David Lametti invoked solicitor-client privilege to deflect a number of questions. Although he was clear on one point, he believes the decision to invoke the act was the government's responsibility, and Cabinet was not limited by the CSIS definition of a national threat. Take a listen.
The inputs can be much wider, have to be much wider when you're a member of Cabinet, when you're making a decision, Governor and Council. There are other inputs that can go into the meeting of that definitional standard that CSIS wouldn't normally use. And so that's very, very important to underline, that it is, while it is the same standard of the same magnitude, the interpretation of that standard is being done according to a wider set of criteria by a very different set of people with a different goal in mind, and that goal is given by the Emergencies Act and not the CSIS Act.
We're now joined once again by Joanna Smith and Chris Nardi. Joanna is the Ottawa Bureau Chief for the Canadian Press. Chris is covering the inquiry for the National Post. Good to see both of you again.
You too, Michael.
Good to see you.
Okay, Joanna, I'm going to get you to start us off because going into this, people were hoping to get a sense of the advice Lametti provided to the Prime Minister. But given that the Justice Minister invoked solicitor-client privilege, I'm wondering whether you, amongst others, got a better sense of that advice.
Not particularly. I think, what we were really keen to have any insight into was the process by which Liberal cabinet ministers ultimately determined the act was necessary. And Lametti wouldn't really offer any insight into that. And so with the solicitor-client privilege, we issue sort of preventing him from answering some of these things fully. We're really left without the answer to the key question: what legal advice did Lametti provide, did the Department of Justice provide to the federal government as a rationale for invoking the act last winter, for the first time, of course, since it replaced the War Measures Act in 1988. And, the commission lawyer, Gordon Cameron, really presented this as a bit of a conundrum. He says we're really trying from the beginning of this proceeding, we try to lift the veil, he said, over what has been made much of a black box around the central issue. And he says we just regret ends up being a absence of transparency on the part of the government and not being able to answer that key question. Lametti, for his part, he said, listen, solicitor-client privilege is not mine to waive. But he also said that if it was up to him, really, he would advise that it shouldn't be waived. He considers this a really important fundamental principle to the way the government works and the role of the Attorney General. So that's sort of where we are with that. And as you might remember, this Department of Justice opinion was sort of key. It formed the basis for a lot of other people's opinions that ultimately led to that decision. So the fact that we're not getting any more insight into exactly what it was is, we're left with that black box as the lawyer described it.
Yeah, so left without it. But Chris, in trying to determine whether the legal bar was met for the Act's invocation, people have been pointing to the definition within the Act itself, and that essentially relies on the CSIS definition of what constitutes a threat. Talk to us about Lametti's interpretation of that, because while he did invoke privilege on certain points, he was very clear on his feeling about what constitutes a threat and who gets to make that assessment.
Exactly, and it was mostly in line with what government officials have told us throughout the last few weeks, and even cabinet ministers previously. And for him, the fact that the Emergencies Act specifically refers to the definition of a national security threat a threat to Canada in the CSIS Act doesn't necessarily mean that it's only limited to that. He said because it refers to it, you can also basically interpret it more broadly, and that is, basically the only little bit of insight that we got into this famous piece of legal advice that we're probably never going to see. And so we know that they interpreted the wording, and the definition of a threat to Canada's security on a much broader spectrum than it is specifically written in the CSIS Act. We also know that CSIS never found a threat that met that definition. They've been very clear about that. So there was none technically. But as Joanna said, we're probably never going to see that because of solicitor-client privilege. And, as Commission lawyer Gordon Campbell said today, he actually complained of it as a lack of transparency by the government of Canada. He lamented that fact because he said ultimately the Commission's goal is to determine was the way or the reason the government invoked the Act legitimate? Did it meet that high legal threshold? And we're never going to see the advice that it used to determine that it, as cabinet, did so rightfully. And to answer your second question, Michael, it's cabinet's decision, Lametti says, to ultimately determine if that threshold is met. And he said, obviously, cabinet did determine that, and on February 14th, they invoked the Act.
Mm-hmm. Now, today is the third day that we've heard from government ministers. And again, lawyers use text messages to help form their questions. And, Joanna, Lametti, again, while not providing a lot, he was pushed hard on a text exchange that he had with the public safety minister. Talk to us about that exchange and why it mattered legally.
So Lametti in this text exchange with Mendicino, and you're right. We're getting a lot of really interesting insight into the things they talk about in their cabinet group chat. So one of the things Lametti wrote to Mendicino was, you need to get the police to move. And I'm paraphrasing slightly here, and Canadian Armed Forces, if necessary. Too many people are being seriously, adversely impacted by what is an occupation I am getting out as soon as I can. And at one point, Mendicino also responded, how many tanks are you asking for, in military tanks? Lametti replied, I reckon one will do. So Lametti did frame this as a joke. I can see, and as a chat with friends, not necessarily in his cabinet role, but I think it can be hard to figure out where one ends and one begins when they are in fact discussing such a serious matter. I can appreciate, I reckon one would do about tanks would have been a joke. It's a little generous, I think, perhaps. We'll see. I'm not in anyone's mind about the whole and the Canadian Forces if necessary when he's talking about getting the police to move. That's a little less obviously haha to me. So we'll see. But I think it does matter because Lametti is the Attorney General and the Justice Minister, and I think in this context he can't separate that fact. And I think also, even if it is a joke between friends, it says something about the atmosphere and what they were all feeling at that time. And I think it's really hard to, just like it's hard to separate Lametti as a person and as a buddy of Mendicino from his role of Attorney General, it's also, I think, hard to separate or delineate where their feelings ended and their sort of legal analysis began, right? I'm not trying to accuse anyone of being overrun by emotion here, but I think that insight that we're getting into what they were all talking about, what they were all thinking at the time, sort of gives us a sense of just how seized they all were with this.
Our thanks to Joanna Smith. Now, let's get back to the Justice Minister, because the Canadian Civil Liberties Association, they were quick to condemn David Lametti's use of solicitor-client privilege, arguing it would make the Commission's work much harder. In fact, Commissioner Rouleau also questioned the tactic. Take a listen.
The job that the commission is to do is to look at the decision by cabinet, and as was mentioned by commission counsel, there's an issue of the reasonableness of it. And I'm having a little trouble, and I don't know if you can help me, how we assess reasonableness when we don't know what they were acting on. And do we just presume they were acting in good faith without knowing the basis or structure within which they'd made that decision? And you know of what I speak, I think.
Yeah. I mean, I think we have done our best to provide all the information we can. The Section 58 report effectively gives you the conclusions that we got to.
Now, the Canadian Civil Liberties Association is taking issue with David Lametti's approach, and joining us right now is Ewa Krajewska. She is counsel for the CCLA. Ewa, thank you for joining us tonight.
Hi, Michael. Nice to see you.
Now, clearly, you've said so in statement, at least the organization has, that you are disappointed by the Attorney General's decision to invoke solicitor-client privilege. How does that hamper, in your opinion, the work of this commission?
So there have now been a number of ministers and Jody Thomas, the National Security Advisor, who all mentioned in their testimony that when they were deliberating on whether or not to invoke the Emergencies Act at Cabinet and at the IRG, they considered a legal opinion that they received from the DOJ. And they've claimed solicitor-client privilege over that legal opinion. And so that's part one. But part two is the way that all of these witnesses have justified the invocation of the Emergencies Act is by stating that they received a certain legal view or legal opinion of how to interpret the CCAC Act. So in order to invoke the Emergencies Act, part of the legal test is that Cabinet has to be satisfied that there is a threat to the national security of Canada as defined in the CCAC Act. And that's become a real point of contention during these hearings because a number of people have kind of spoken to that interpretation. But we don't actually know what the DOJ said to Cabinet. We don't know what DOJ advised. We don't know how they interpreted that. And so when Commissioner Rouleau is saying, are we to take it on good faith that you received an opinion that justified this invocation? You know, are we just supposed to take that at your word, right? Or did the DOJ say, well, there's lots of risks with this, right? There's lots of risks, and this is a political risk you're taking in doing this. So it does raise a very big question because the commission, the ministers are relying on this to say that they acted in good faith, but they're not giving it to the commission or the public for the public and the commission to be able to assess whether Cabinet was actually acting in good faith. Okay,
but correct me if I'm wrong here. Does it matter at all that we heard from Lametti yesterday that the act should not or is not limited by this CISA's definition of a threat to the country?
It is. He agrees that it is. He absolutely agrees that the act says by incorporation that it's a threat to the country. He agrees with that. The issue, the dispute is he says it's not CSIS who assesses the threat, it's the governor and council. Okay, that's a legal argument. But I think the question is it still the same threshold? Like he's saying the CSIS Act says there's a threshold before you can conduct surveillance on Canadian citizens. And we would say whatever that threshold is to conduct surveillance on Canadian citizens, it must be as high or higher if you are going to be invoking the Emergencies Act in order to suspend civil liberties across the country.
Now, can't the commission decide if a legal bar is met just by looking at the circumstances as outlined by ministers, if not the exact wording of the DOJ's advice?
Well, that is the position that they are being put in, which is, you know, you're going to have to just rely on the evidence that's put forward. But the commission, the DOJ and the government have also waived a number of privileges. So they normally Cabinet confidence would cover all inputs that went to Cabinet, and they waived that in order to enable the work of the commission. So, it's interesting that the DOJ has chosen to waive some privileges in some circumstances, but has decided not to waive other privileges in other circumstances. And they are, in my mind, cherry picking some of this. And, they assert privilege over some of Lametti's testimony when they feel like they don't like what he's saying, but then they let him provide legal views and legal opinions on other parts of his testimony.
So what's the practical impact then? Given that this is the tactic that the Justice Minister has taken to essentially invoke solicitor-client privilege, what's the practical effect on the final report, do you think?
I think we're going to see what the effect is. The commission, the commission can write it in a way to say, based on the evidence we've heard and based on what we were able to access, these are our conclusions, right? They can say based on what we've heard and what we were able to access. So that is the implication. I'm not sure.
But an incomplete picture. But an incomplete picture. Your fear is.
And maybe they could say, the commission could say, we are disappointed, or we felt like they should have waived this privilege or provided us with this legal opinion on the basis that they've been relying upon it. And there is a lot to support that. There is a lot of support that if you go out and rely on the legal opinion, that you've potentially waived that solicitor-client privilege.
Ewa, thank you for this. Really appreciate the time tonight.
Thank you, Michael. Bye-bye.
There was one very unexpected moment at the commission this past week, a testy exchange between a protest lawyer, Brendan Miller, and the inquiry's commissioner. A back and forth that eventually led to Mr. Miller's expulsion from the room.
The Government of Canada has redacted without lawful authority all of these statements from these staffers and have suppressed records.
I have no idea at this point where this is going, so I'm going to take the break. And if you can speak to Commission Counsel, which I think I've repeated many times, is the way to at least raise the issue.
Yes.
And then we'll see if they can resolve it
Yes.
or not. But we have a schedule. And
sir, the schedule is not as important at getting to the truth.
There's no question we want to get at the truth, but you know what? It's a very complex issue, and it's not all about what you want. The application, if you want to do it, you've been advised it's to be done in writing, not in the middle of the
Sir,
presentation.
we filed 2 motions in writing at your direction that you've refused to rule on with respect to the redaction of documents from the Government of Canada.
You're speaking,
that has not been ruled on, and they've been filed for days.
I will take a break while you're asked to leave. I will return in 5 minutes if security could deal with the council.
Well, with more, we're now joined by Tonda McCharles, parliamentary reporter for the Toronto Star, who's covering the inquiry, and Joanna Smith, the Ottawa bureau chief for the Canadian Press. Hello to the two of you.
Hi, Michael.
Hi, Michael.
Hi there. So I do want to begin with what took place, the ejection from the room, because that exchange that we heard, it really seems to go to 2 issues here. One has to do with the Public Safety Minister's Director of Communications, the other about documents the government is releasing to the inquiry and portions of those documents that are redacted. Now, Brendan Miller is the lawyer who was ejected. He says both are needed to get a full picture of what happened. How true is that statement, Tonda?
Well, I mean, the judge ruled not much longer after that whole scene broke out in the inquiry room that, in fact, the documents were rightfully redacted, that the evidence which he got to see unredacted was either not relevant or was protected by cabinet privilege. So he did basically rule against what the convoy lawyer was saying, that it was so relevant that it had to be brought in immediately and that he had to be able to call one of the minister's staffers who was in the room. Look, it was much ado about much less than meets the eye, really, because fundamentally, the lawyer for the convoy is putting forward a theory that, the whole attempt he's putting forward a theory that there's a political attempt by staffers in the government to paint the convoy protesters as extremists from the get-go, from before the convoy arrived, in order to be able to invoke emergency powers against them. And so he's pulling together all kinds of strings out of thin air somewhat, and in the process, is really, I think, casting a bad light on actually what the convoy organizers themselves are trying to argue here, which is that the act itself and the government's use of it was an overreach. It's off on a tangent, if you will. It's quite difficult to follow, and it's resulted in a libel notice being issued today against the lawyer for espousing those views.
Now, not only did Justice Rouleau issue his own judgment on those redacted portions of documents, Mr. Miller was allowed back into the inquiry room. And, Joanna, given what we just heard from Tonda, I'm wondering, from what you saw, did his line of questioning reveal any new pertinent detail or information?
Not really. As Tonda said, this lawyer seems to be really focused on this idea that not only the government was trying to paint everyone as extremists from the get-go, but was engaging in some sort of subterfuge, really playing up the idea, like taking advantage of the fact these protests were really divisive, and sort of, he's putting forward this unsubstantiated theory he has that the government might have actually gone so far as to plant some operatives like agents provocateurs who were responsible for the presence of hateful imagery such as swastikas and Confederate flags in the crowd as a way to influence public opinion. And like Tonda said, a lot of this is really seems to be strings coming from all over the air. So I think, he keeps pushing this point, and it's really raising the ire of the commissioner, and that's sort of the tenure of those exchanges today.
Okay, so that it took a lot of oxygen out of the room today. But let's switch over to the testimony that we did hear, beginning with Marco Mendicino, the public safety minister. Now, he talked about the RCMP, CSIS assessments, but also, I guess, shared some of his reasoning for invoking the act. Take a listen right now to Marco Mendicino.
My concern, in my capacity as the Minister for Public Safety, is that if we don't equip police with the additional tools and the authorities that they need to specifically address the gaps that they had been consistently briefing us on, then that might lead to more violence. And so we also had to weigh the risks of not taking the decision to invoke. And so that we weighed in the potential concerns around radicalization, but ultimately we came down on the side of invoking.
Now, the public safety minister's conversation, his testimony today, took up a lot of time. I'm wondering, Tonda, from listening to Marco Mendicino, do you have better insight now into his justification for invoking the act?
Well, to this extent, I mean, we've heard now, actually, the third minister is on the stand, and he just completed his examination in chief. So, look, we've heard from three different ministers what was, I guess, the salient point for them. Minister Blair yesterday talked about the border blockades and the economic damage being what tipped it over into a national emergency for him. In Marco Mendicino's mind today, what tipped it over for him, it seems, was a conversation he had with the RCMP commissioner around the weapons in Coutts. And this was at a critical moment just before a cabinet meeting on Sunday, February 13th, where they were going to weigh invoking the Emergencies Act. And he says he doesn't recall seeing her email that expressed her reservations about the Emergencies Act, but he does very clearly recall her alarm at what the RCMP believed was present at the Coutts blockade in a trailer there. They had undercover RCMP officers who, she said, lives were on the line if word were to leak out about a pending raid on the blockade in Coutts that ultimately produced a cache of weapons and charges against 13 individuals. So look, for Mendicino, he says that was the tipping point for him. But he very much made the point, it wasn't about just that, or it wasn't just about the Ottawa convoy, which he called had resulted in utter mayhem, I think is the word he used for Ottawa. He said, let's call a spade a spade. It was chaos. Well, he says it wasn't just about Ottawa or just about Coutts. He said it was, in his words, the totality of what was going on across the country, and that they really didn't think that police were effectively using, even if they had existing tools, were effectively using them.
Okay, not effectively using them, according to the minister. But, we did hear from the RCMP. We've heard from the Ottawa Police. We heard from the Ontario Provincial Police. And each one, when they testified, they stated they did not ask for the act to be invoked. So talk to us, Joanna, about how the minister responded to that.
it was a sense that that wasn't the impression he was given, right? We had heard about this email that Brenda Lucki, the RCMP commissioner, had sent to Mendicino's staff about this idea that not all tools had been exhausted. And he said, that never made it to me. As Tonda said, that conversation he had with Lucki, he really came away with the impression that she supported the invocation of the Emergencies Act. He went so far as to say, this was a threshold moment for me. So that was sort of your sort of understanding that maybe this was a huge issue of miscommunication, which was frankly a problem throughout the whole protest to begin with. But you're sort of coming away, I think, with the impression that everyone was viewing things through a slightly different light. Everyone was maybe coming into things with preconceived notions. Everyone was making a lot of assumptions about what everyone else was thinking and how and why they were going to act. So I feel like that's a common thread that we saw reinforced today with Mendicino. And there was another interesting moment when he was sort of asked, if you had to sort of pick protests and responses to protests, is that sort of an appropriate thing to do? And he in terms of, responding to the border versus responding to Ottawa. And he says, it's not the kind of choice or dilemma you want to be in on where you want to focus your energies. And he was really sort of talking about this in the context of this question of potential political interference in police operations. So he said, elected government should steer clear of that. That's a slippery slope. So if we're talking about a situation, if that's where his thinking is, and if the RCMP is, according to him, telling him that this is what we need, then you can kind of start to see how these decisions ended up being made.
Mm-hmm. Quickly running out of time, so I'm going to ask for Go ahead,
I just want to quickly say that notwithstanding whatever reservations Lucki conveyed to the minister or didn't convey, in her letter is a whole list of bullet points of useful tools that the RCMP thought the Emergencies Act could give them and how they would be used. So it wasn't as if she was just saying, don't do it.
Our thanks to Tonda McCharles from the Toronto Star and Joanna Smith from the Canadian Press. Also thanks to Chris Nardi, parliamentary reporter with the National Post, who helped us with our coverage this past week and who you saw earlier in the program. That is it for us this weekend. I'm Michael Serapio. For everyone here at CPAC, thank you for watching. We'll see you again tomorrow.